Mr. Desh Ratan Nigam, how do you respond? First of all, the larger point on this, I'll come back to you, Mr. Shamsi. Desh Ratan Nigam, the larger point of this being religion neutral. I mean, if you want to attack land grabbing by religious organizations or by people affiliated to those religious organizations, trusts, boards, then let this be a religion neutral exercise. Then take action against all.
Sanket,
who will oppose?
Sanket, let me tell you, ignorance of law is no excuse, and since Owaisi is not there, so I'm not going to laugh at his ignorance of law. The Section 6 of the Waqf Act, UP Waqf Act 1960, clearly provides for a survey, and there are parameters laid down there, so nothing illegal. It is done under the Waqf Act itself. Under the Endowment Act, Hindu Religious Endowment Act, the control of temple is taken by the government. It is other way around. The land is grabbed, it is disposed of by the government. The revenue collected by the temple is used for some other purposes, so you can't compare the two. One. Secondly, let me also point out, Waqf is not mentioned in Quran, and it is given in some Hadees. And there are large number of Muslim countries. Since it is not mentioned in Quran, they do not recognize Waqf. And there are huge number of countries, and I named some of them. There is no Waqf in these countries, which include countries like Turkey, Libya, Sudan, Egypt, Jordan, where the descendants of Prophet Muhammad are actually ruling. Tunisia and Iraq, just to name few. They do not recognize Waqf, and there are no Waqf in those countries. And some Islamic countries do recognize because they are governed by Sharia law. India is not governed by Sharia law. India is governed by constitution. Therefore, the constitutional validity will be seen in Supreme Court. The matter is pending there. So far as UP Act is concerned, let me also tell you, this Waqf Act in various states which is existing apart from other acts, I'll give you a few examples. A Tamil Nadu example where they have claimed the entire village where more than 1500-year-old temple is also there, that they have also claimed. In holy city of Dwarka, which is so ancient, the archaeological says it is about 9,000-year-old, the Waqf board claimed the two islands of those holy city of Bet Dwarka. So such arbitrariness is clearly seen. No time period is mentioned. The act says if it is for a very long period, then it's a Waqf property, then it will be deemed as a Waqf property. Time limit has not been defined. So many arbitrariness is there in this act. And secondly, also let me tell you that there is a Privy Council judgment when there was no Supreme Court in India. 4 judges in London, sitting in London, who used to decide about India, have clearly held Waqf as invalid. They have said, they have described Waqf as a perpetuity of the worst and the most pernicious kind and declared Waqf to be invalid. Subsequently, the Indian British government did not, accept it, and they passed a 1913 act, which is known as Mussalman Waqf Validating Act, not to obey that judgment. Believe me, in 1947, when India became independent, all the Waqf properties vested in Government of India. But because of appeasement politics and surreptitiously, quietly, a 1954 Waqf Act was passed, and subsequently,
so from what I gather, from the argument that you have made, Mr. Desh Ratan Nigam, you are saying that this number one cannot be compared with other religions, particularly a temple, trust or a board. You also say that there is a provision within the Waqf law which mandates a survey.